Well, thank you very much, everybody, for joining us. A formal welcome. You've put up with the banter. Hopefully, this is the good bit. I have to say that the new arrangements for post-COVID possession are looking incredibly dry to me. So there may not be any highlights in my bit, although Henk will no doubt have plenty of highlights in his. Thank you for joining us both. I'm going to do the first part of the presentation. Henk is Soede, and so important to get these names right. We'll then take over, and then we'll do some Q&A at the end. As I popped in the chat, if you can put Q&A in the Q&A, that's great. But if you put them in the chat, we'll probably get to them as well. So we're all there. I'll start with the fascinating topic of notices. There are new forms 3 and 6A, which of course are your Section 8 and Section 21 notices. There are new notice periods for all notices, and then just because there aren't enough notices on this planet, we have a requirement for reactivation notices, and those are the bits of the COVID-related arrangements that I will be looking at. The first thing is when we're now bringing claims again. Obviously, everybody was still able to bring claims during lockdown, but I think, or during the stay, but I think there was an easing off. There is the web link for the new versions of Form 3 and Form 6A, and they have very full details of the new notice periods. I will go through them here. Section 21 is lovely and easy. It's a 6-month notice period now. I say lovely and easy, landlords will not think it's lovely at all. And because of the increase to 6 months, you now have 10 months to start a claim within the date of the notice. And obviously, for tenant advisors, if it's been started thereafter, the claim should be dismissed, and the landlord will have to start again. Section 8, sadly, is not quite so simple. So hold on to your hats. Ground 14, if it's being relied on its own or with any ground other than 7A, you can your notice period is effectively no notice period. Once the notice is served, you may commence proceedings. 14A, 14ZA, or 17 without ground 7A or 14, 2 weeks. The one that most of us will be using or interested in or defending against are grounds 8, 10, or 11. Again, without ground 7A or 14, there are two. I've read them both. If you've got at least 6 months rent unpaid at the service of the notice, you have a 4-week period. And down the bottom there, if there is less than 6 months rent unpaid, it has a 6-month notice period. It may get into a position where once you've got, let's say, once ground 8 is engaged, you serve a Section 8 notice with a 6-month validity because you've got 2 months of arrears, that is to say. And then again, 4 months later, you can, without prejudice to your first notice, you can serve another Section 8 notice, and that would have a 4-week notice period. So you save yourself about a month. It's possibly not much of a bonus for a landlord, but at least with where there's 6 months rent, and there does seem to be a feeling through these new regulations that landlords are to be protected in cases of excessive rent arrears. Because again, when we come to see the prioritization arrangements for how cases are dealt with, those cases with serious rent arrears are, in theory, to be put to the front of the queue or have a chance of being put to the front of the queue. So 8, 10, and 11, if you haven't got 6 months notice, 6 months of rent unpaid, it's a 6-month notice period. But if it's at least 6 months, it's 4 weeks. Ground 7A, with or without other grounds, is a month. Ground 7 or 7B, 3 months, and anything else is 6 months. I've dashed through the rest of them because I think most of us will be dealing with 8, 10, and 11 most of the time, but it's all there if people need to refer to it at some point. You will see a slightly different Form 3. It sets out the new notice periods within that, so I think it's very sensible to check because of their rather labyrinthine requirements on if you're using relying on grounds with other grounds. And now the claim needs to be issued within 12 months of service of a Section 8 notice, as opposed to 10 with a Section 21 notice. It may mean that people prioritise claims relying on it. Sorry, that people choose to serve a Section 8 notice where they can, rather than a Section 21 notice, where I think generally the practice is to favour Section 21 notice, because assuming you have ticked your boxes as to how to rent booklets, gas safety regulations, etc., you're not going to be defeated by a disrepair counterclaim. And while I'm possibly very cynical, I have yet to see a Section 8 notice that hasn't been met with a counterclaim for disrepair, which obviously in cases where it is well-founded will defeat the claim, but in cases where it's not well-founded may end up delaying the claim, which is perhaps as bad for a landlord who's not in receipt of their rent. Now, Practice Direction 55C, which is available at that link there at the justice.gov.uk site. That's had a couple of versions, actually. A couple of the dates changed slightly in it. So that is the most up-to-date version. For those people who use Westlaw and the like, their version is up-to-date. And the one on the government CPR site is also up-to-date. It is intended to provide for temporary modification of Part 55 during the period beginning the 20th of September 20, which was, of course, the end of the stay after it was extended, and ending on 28th of March 2021. We're calling that the interim period. Whether that's because the makers of this practice direction hope or believe that the backlog will be dealt with by the 28th of March, or whether they simply felt that 6 months was a reasonable period because it's been made without full parliamentary scrutiny, of course, that 6 months is a reasonable period, is perhaps open to debate. The practice direction splits claims into two broad types. They have, in paragraph 1.3, a stayed claim. Now, a stayed claim, you might think, is some claim that was stayed, which you'd be right. Any claim brought on or before 19th of September. Now, that expressly includes appeals from claims brought before that date. And I'm stressing that because as we go on, there's an element of doubt there, certainly in my short experience of the new regime. So the opposite of a stayed claim is a new claim, and they define new claims as any claim brought after the 19th of September, so 20th onwards. What do you have to do if you have a stayed claim? Paragraph 2.1 tells you, subject to paragraph 2.2, and unless the court directs otherwise, so the practice direction specifically gives the court a few get-outs with this phrase, unless the court directs otherwise, as you go through the PD. Stayed claims will not be listed, relisted, heard, or referred to a judge under 55.15 without a reactivation notice that has been filed and served by either party. Now, I suspect that the vast bulk of parties who wish to serve a reactivation notice will be landlords, but either party can serve them. Paragraph 2.2, to which 2.1 is subject, states that an exception are claims brought on or after the 3rd of August 2020, or in which a final order for possession has been made. Now that to me excludes final orders for possession that have been made that are now subject to an appeal. But I have to say that in one claim that I've been involved in, a reactivation notice has very properly been served by the claimant, and the court has said you don't need a reactivation notice because there has been a final order for possession. Well, because it says there has been a possession order. Now, that is under appeal at the moment, so I question how, and indeed if, absent a reactivation notice, the court will start the process moving on hearing of that appeal. It may well get to it. There may be a special box with final orders of possession that are subject to an appeal, and they'll be working through those in just the same way. But if that decision from the court doesn't seem to accord with my understanding of the practice direction. So what do you have to put in your reactivation notice? Well, 2.3 tells us it must state that the party wishes the claim to be listed, relisted, heard, or referred, as the language of 2.1 is repeated. And it says, except in the case of an appeal. So it is clear that appeals are caught by some of the practice direction. The party has to state what knowledge that party has as to the effect of the coronavirus pandemic on the defendant and their dependents. Now, importantly, there's no obligation on a landlord to make inquiries. And if there is a reactivation notice that says, for instance, we have no knowledge as to the effect of the pandemic on the defendant and their dependents, tenant advisors will be well advised to put in their representations, these are, if there are such impacts. And they can be, of course, financial for those people who perhaps lost their livelihoods, or had a reduction in their earnings. It can be health related, in that somebody who may be shielding or otherwise vulnerable would be at more danger if they were to be made homeless. So any possible impact, if you're acting for a tenant, that relates to your client and can show the court that they have a greater effect from coronavirus will be worth putting to the court. 2.4 also says that in claims that are based on arrears of rent, again with the exception of appeals, a claimant is to file and serve with their notice an updated rent account for the previous 2 years. So a slight twitching, if you like, of the usual rent history, but you have to serve a new one, even if there's been one before. 2 years in a rent-based claim. 2.5 says that any trial date, it doesn't say hearing date, with any trial date set before the 27th of March, so that's before the 27th of March 2020, will be vacated, again, unless the court orders otherwise, so they give themselves a bit of leeway, unless the appropriate reactivation measures have been carried out not less than 42 days prior to the hearing date. So there's a bit of an onus there to landlord representatives to get the house in order and to get it in order pretty early. So if no party files a reactivation notice by the 29th of January next year, the claim gets stayed. Technically, all that means is it's expressed as specifically not being a sanction. So you don't have to make an application for relief if you don't, and it can be lifted simply by application. It doesn't say how, but I presume in Form N244. Whether you need, with your application to lift the stay, to comply with those parts of paragraph 2 of the practice direction that apply, and to file, for instance, to file a reactivation notice, it doesn't say. I'm not sure. That will be a matter that may be coming up next year. It's hard to say. I would say, given that there is so little work involved in filing a reactivation notice in the context of bringing a possession claim, I'd say anybody who does want the claim to be reactivated and then wants the stay lifted would be well advised just to do it in any event. What the practice direction also does is build in some time leeway for the court. Paragraph 3.1 says the court will give parties at least 21 days notice of hearings that they then list or relist in response to a reactivation notice. But again, it says unless it directs otherwise. Given that the courts don't always, putting it very neutrally, hold to the deadlines that they're meant to work to, I suspect that even in these more difficult times, even given the extra resources in terms of DDJs that we've been told that courts have been supplied with, I think there will be occasions when the court will direct otherwise. It's going to happen. The courts won't become more efficient. I would suspect, in these difficult times. They may not be less efficient, but I don't think they'll suddenly get more efficient. 4.1 modifies CPR 55.5 by expressly disapplying a requirement therein for a standard 8-week period between issue and listing. Between issue and hearing. So again, the emphasis of the practice direction is to give the courts a bit more time to spread out hearings, because part of the issue is that, of course, there'll be far fewer physical courts available. Listings will be much reduced from what they were. You won't get this long block listing of possession claims on a Wednesday in court X, Y, or Z. So they're going to have to prioritize or triage cases, and they will push things back. It's going to take longer. So how will they case manage those claims that have been reactivated? Paragraph 5 says the party filing a reactivation notice must file. This is where case management directions were made before the 20th of September. So if you've got your claim started during the stay, or probably before the stay, because your case management directions should not have been made during the stay, although again I think some have been. I've had one. When you file your reactivation notice, you must file and serve with it a copy of those last directions named with new dates for compliance. Now, I suspect that means that if a date for compliance was 14 days, then it would be 14 days from lifting of stay. That's just a guess, but it seems logical. And you have to have either alternative or additional or alternative directions, including the proposing of a new hearing date, which is interesting because how do you know what the listing arrangements are going to be in the court? But there we are, you're asked to do that. Or if not, you just simply have to state that no new directions are needed and that an existing hearing date can be met. Now, if you remember that hearing dates will be removed, if you want to preserve your hearing date, get active as either party and serve a reactivation notice and say this can be met. And logically enough, given the volume of new remote hearings, in any case, you have to state whether your claim is suitable for hearing by video or audio link. Now, 5.2 says that if one party files and serves this, and the other party doesn't agree, which is sensible enough, they may say we think a better set of directions would be this. They file and serve their response within 14 days, which is pretty sensible and uncontroversial. So failure to comply with 5.1, so you may still file your reactivation notice, but if it has case management directions made before the 20th of September, if you don't file your copy with your new date and your additional or alternative directions, or your statement you don't need any new directions, you don't put those in, you get stayed again. I am uncertain, because it doesn't say, how a party knows that they have been stayed. There may be a standard notice that will come out from the court saying, because of this failure or that failure, you have been stayed. They will go out after 29th of January next year. That will be a joy that we will face in the new year. There's much that I don't know, that I think a lot of people don't know. We are all in completely new territory. So for new claims, that second category of case, paragraph 6 deals with those. New claims are brought after the 3rd of August. Landlord must, so they would have been brought and immediately stayed. You have to bring 2 copies of a notice setting out their knowledge, again, this knowledge of the impact of COVID on the defendant and their dependents, misspelled, my apologies, and send a copy of that to the defendant not later than 14 days before the hearing. So you don't have to file and serve that, sorry, you don't have to serve that at the same time as you file and serve your reactivation notice, but it might save you a step if you do so. And For claims where the pre-action protocol for possession by social landlords applies, a claimant must also do the same process but with an extra document, serve 14 days before, and then bring 2 copies of the hearing, a notice stating that the protocol has been complied with, and set out how. Now, I think that's going to be a very interesting point. As a tenant advisor, you will face a lot of claims where the evidence for compliance with that pre-action protocol is sketchy, to say the least. Quite what the court does varies. I think more honoured in the breach than the observance. I haven't had a claim dismissed, or I haven't had a landlord adjourned, or a social landlord adjourned on it and told to come back, having said how it's complied with the pre-action protocol. Maybe some people have. And if you have, shout, because I don't think I've ever known that. But they're specifically saying that social landlords have to say how they have complied with that pre-action protocol. Although, as I put at the bottom, there isn't any sanction stated for that. So again, it will just have to be something we find out how courts will react to that. I wonder again whether that is going to be a further tool that courts can use out their hearings, and they can then send back a claim by a social landlord with an order saying you must tell us how you've complied with the pre-action protocol within a certain period, or face some other kind of sanction. You don't have to use any particular form of reactivation notice, and the actual contents, as we've seen, are not onerous. Just say, please relist us, and this is what I know about the impact of COVID. And as I said, in many cases, it will be nothing whatsoever. And for those advising landlords, I would say I wouldn't go advising my clients to start making inquiries, possibly a little cynical, but it's not a sleeping dog that you have to wake up. Obviously, if something is known, it must be disclosed to the court, but there's no obligation on anyone to ask. So the form of reactivation notice, there are 2 forms, both for a claimant and for a defendant. Those were issued on the 15th of September, and there's the link there. Use is not mandatory, but I don't see why you wouldn't want to use it. And there's a sweet little sort of hint on the claimant one going, oh, you might like to check what the impact of COVID is. But as I've said, I couldn't necessarily advise a landlord client to do that. They're not obliged to. It may be felt that it would be good practice, particularly for a social landlord. But as I say, it's not an obligation, and I wouldn't feel it was my professional duty to tell them to do something they're not obliged to do. Now, the claimant's version is very helpful in that it lists a number of suggestions as to cases in which claims might be prioritised for case management, which is part of what Henk is going to be talking about. And it has a long list of how a landlord may gain what it says priority consideration. So significant antisocial behaviour. Obviously, the notice period remains nothing for antisocial behaviour claims. Significant, well, I suppose that's an elephant. We know what it is when we see it, but there's no fixed definition. Extreme rent arrears, and they do define that. So at least 12 months rent is in arrears, that's extreme. Or, and this is harder, in the case of a private landlord, 9 months rent if that is at least 25% of the private landlord's income. Well, good luck to A, landlords trying to evidence that, and B, anybody trying to dispute it, and C, the courts trying to work out whether it is in fact extreme or not. Squatters, illegal occupiers, or persons unknown. So specifically, whereas claims against persons unknown were not stayed, squatters, illegal occupiers are also added as a priority case. Domestic violence where possession of the property is important, and I put a little question mark there because I can't imagine a case where possession of the property wouldn't be important in a domestic violence claim, but that's what the practice direction says. Fraud or deception, unlawful subletting, abandonment, non-occupation or death of the defendant. So a sort of group of some negative behaviour by or on behalf of the tenant, and then other things that obviously death of the defendant. You're looking at failed succession cases there, I guess. And where the property was allocated by an authority as temporary accommodation and is specifically needed for reallocation as such. That makes me think of a number of cases that I've been involved in where local authorities have obtained property from private landlords and have then housed people either under the duty or the under their discretion to house while decisions are made. But the ground very often is that that private landlord requires it back. So that would be ruled out under this. It is specifically needed for reallocation as temporary accommodation by the authority. So bit of wiggle room in that prioritisation. Now, all of this would then be put in and presumably evidenced. It doesn't say what evidence has to be put in, but you're going to have to evidence something about extreme rent arrears being 9 months rent that is at least 25% of a private landlord's income, and then a response within 14 days by the other party saying what they want to say. It's interesting, and it's going to a degree increase the weight of litigation in these cases, or the expense of litigating them rather than the weight of litigation, and obviously the steps to be taken. I'm not saying it's not proportionate, but it is going to catch lots of people out. It's fiddly, a bit like Section 21 these days. The explanatory notes helpfully say that the claimant should tell the court what they know of the impact of COVID on the defendant, but that they can also rely on adverse financial consequences that they, the claimant, have suffered from COVID-19. So they're being urged to give the courts reasons to push the case forward in case management, as well as the obligation when they know of something that may cause the court to move it back in the claim, i.e. the impact of COVID on the defendant. They are obliged to tell that. So bumping it up and down the queue. And I know Henk is going to look at, in one of our discussion points, how that prioritisation might work. We don't know, but just some thoughts about it. So what are we looking at in the brave new world? Well, use your right new notice, funnily enough. We all know we couldn't use the right notice, but use the new form, check the period on it, and put the correct notice period when you're seeking possession, because as usual, if it's wrong, we will get in trouble, whether being wholly unable to rely on our notice, which I think you probably would if it were ground 8, or whether you have to just go back. 2, most claims that have been issued on or before the 19th of September will need to be reactivated. And as I've said, if in any doubt, why not put in a reactivation notice? Because it's not onerous in itself. It's not going to cost your client a lot of money to do. Now, it says it doesn't apply if there has been a final possession order. I've raised the question of whether, when that is under appeal, it applies. Again, I would, if I were a landlord, I would be saying, let's do this, let's comply just in case. 4, the official form is not mandatory, but it's handy. Why not use it? Saves drafting time. I have been on one case where, I think it was before the form came out actually, where we just sent in a letter, and it didn't add much to the letter to the court saying, please relist, this is what we know of the impact of COVID on the defendant and dependents. But why not use the form? There is no obligation on landlords to seek information about the impact of COVID on the defendant, although the obligation is there to tell the court what you do know. If they are required, make sure that new directions are included, that you comply with those bits of paragraph 5. And it helpfully says you can wait until, there's no hurry, it says. You can wait until January 2021 for reactivation. I don't know why anybody with a stage claim would want to delay reactivation, but there may be cases where a social landlord is happy to wait. A private landlord may be getting rent and therefore is not worried. But I think in the vast majority of cases, given that we don't know how long things are going to take, but that we suspect they will take longer, I think most landlords would want to get claims reactivated rapidly. As a landlord, 8, can you get your claim prioritised? Use those factors that are actively suggested by the reactivation notice form. And as tenant advisors, what can you do to give your client the greatest possible period of security in the home? Any impact of COVID, financial, health-wise, there may be loads that aren't obvious to us until we meet somebody with that impact on them and on their dependents as well. Remember that. Those are the points that I want to go through with you. Henk is going to take over. I'll mute myself and I'll try and have a look as we go through on the questions that have come. Unless there are any questions that you thought most appropriate to deal with now, Henk.
So we've got one question from Lawrence and another from Neil. I think the question from Lawrence, it makes more sense to deal with it at the end of my presentation because I do address some of the points that Lawrence makes. And I hope I've answered Neil's question, but I'm sure he'll tell me if I haven't. And those are all the questions we have so far.
What was Neil's question? I'm interested.
Sorry, say that again.
What was Neil's question? I'm interested.
Neil's question was, is there any guidance as to what the impact of COVID-19 is? Does it mean financial impact, which I would have thought would be obvious? And I pointed him in the direction of the specified information set out in the overall arrangements. And it seems to kind of encompass health impacts, but largely financial impacts. So I think Neil is effectively right.
I urge everything, first rule of the bar, don't ask, don't get. If you think there's any arguable impact on your client either way, as tenant or landlord, put it before the court.
Yeah.
The list of potential factors is not exhaustive. I agree, Neil. It will be largely financial, but don't forget any of the others.
Yeah.
Okay, cool. Thanks, Henk. I will mute myself and I will.
All right, thanks very much for that, Richard. So firstly, it's nice to meet everyone, and thank you very much for attending today. So, as many of you will know, the overall arrangements were introduced on the 17th of September 2020. And they involve and are supported by the amendments to the CPR and PDs. But they also include a wider range of guidance. The court's going to apply this guidance as they begin to process the massive backlog of possession claims. So in today's talk, I'm going to address the key points in these overall arrangements and also hopefully highlight some areas of uncertainty. So the natural starting point really when considering the overall arrangements is the stated aims. And the strategy in the overall arrangements is directed at 3 aims in particular. So the first of these aims is reducing volume in the system by enabling earlier advice and increasing settlement. And the second, taking account within limits that the law has imposed the effect of the pandemic on all parties. And the third, maintaining confidence in the fairness of outcomes. Now, for those of us practicing in this area, it will pay to keep these purposes in mind, because the courts have reserved to themselves a number of discretions, and it's extremely likely that the court will have regard to these aims when deciding whether or not to exercise that discretion. So, in terms of the substantive arrangements that have been introduced, there are a number of important policies relating to the court's case management and listing powers. So the first is obviously the reactivation notice, but Richard has addressed that in good detail, so I won't go into any more detail on that. The next most important policy is, or not so much a policy, but a rule, relates to the fixing of hearing dates. So as Richard pointed out, Practice Direction 55C para 4.1 specifies that the court will fix a date for the hearing when or after it issues the claim form. Now, the wording when or after allows for some optimism, but the overall arrangements provide differently, and they make clear that, quote, generally speaking, the court will not fix a hearing date when it issues the claim form, and it will almost always fix a date after the claim form has been issued. So taking those points together, it seems clear that parties can expect long delays in the management and hearing of their possession claims. And I appreciate that probably isn't a surprise to many of you. So with this potentially lengthy delay in mind, landlords will be thinking about, how do I get to the front of the queue? And tenants will be thinking about, how do I get myself to the back of the queue? And so the issue of prioritization is likely to be an incredibly important battleground in the coming months. So the Master of the Rolls has issued guidance as to the sorts of cases that would generally be considered to be a priority. And these are set out as slide 16. If we could just turn back to slide 16. I can quickly go through it in any event. So the cases that will have priority are cases with allegations of antisocial behaviour, cases with alleged extreme alleged rent arrears, cases involving alleged squatters, cases involving allegation of domestic violence where possession of the property is alleged to be important, cases with allegations of fraud or deception, cases with allegations of unlawful subletting, cases of allegations of abandonment, etc. So the provisions in the overall arrangements make clear that this categorization is a guideline, and that there may be other circumstances not contained in the guidelines that warrant priority. And so parties will, I'm sure, try to obtain priority, even where the circumstances of their case don't fit neatly within any of the priority categories. And it probably makes sense to do so given the likely delays that most parties will face. One of the key issues that we've identified in this prioritization scheme is that the overall arrangements are extremely light on detail as to how district judges will analyse the issue of priority. And if I could just focus your attention quickly on the various categories of priority cases, if we could go back to slide 16. So, in our view, one of the key uncertainties is that it isn't clear whether priority will be binary, so a case is either priority or it isn't, or a sliding scale, so different degrees of priority. So let's consider an example. A claim is brought involving an element of deception, and so it falls within one of the categories of priority. But will that claim be afforded the same level of priority as a case involving a more substantial allegation of fraud? Or will it be the case that the allegation of fraud is actually attributed a greater degree of priority? And we're not aware of any guidance that's been given to district judges on this point. Taking everything together, it seems to us that it's more likely than not that priority will be on a sliding scale, and probably certain categories of cases will have more priority, as it were, than other cases. Unfortunately, it's not exactly clear what this hierarchy is going to look like. So there's a second uncertainty, and this is how the priority scheme will interact with the COVID-19 case marking scheme. But because I haven't yet discussed the COVID-19 case marking scheme, I think I should deal with that when I do. So the review date. Once a case lands in front of a judge for directions, this will be the first date listed. And the R date effectively is an extremely short, I think roughly a maximum 5-minute appointment, where the judge considers the dispute on the papers. So the key point here for landlords in particular is that at least 14 days prior to the review date, the landlord is required to provide a full bundle with all of the requisite papers and confirmation that they will be available to discuss with the tenant settlement on the R date. So 2 points to make in respect of each of those requirements. So what happens if the landlord fails to provide the requisite papers 14 days prior? Well, the overall arrangements make clear that, quote, the court can be expected to dismiss the claim or may give directions. Importantly, parties are afforded an opportunity to apply for reconsideration at an oral hearing. So the word expected indicates to us that there's a real risk that the court will dismiss a claim if the papers are not in order on the R date. But if a claim is dismissed, the rules allow for a party to apply for a reconsideration hearing. The guidance isn't clear about the nature of this hearing. So is it a relief from sanctions application? If so, how will the relief from sanctions test apply? Or will it simply be sufficient for the claimant to show that they now have the hearing bundle in order? And all of these questions are unanswered. Our view essentially is that if, as a general rule, the court were to stand by its dismissal of a case at an oral reconsideration hearing, despite the court bundle being in order, that would be an extremely unfair outcome. And it seems to us that as a matter of fairness, the presumption should be that if the landlord gets their papers in order at or prior to the oral reconsideration hearing, the claim should be reinstated if it's been dismissed. Otherwise, it would, in our view, again, be quite a draconian provision. So, in terms of the purpose of the R date, it seems from the overall arrangements that the purpose is effectively to provide the defendant another opportunity to obtain legal advice. And this opportunity is provided pursuant to changes to the legal aid duty scheme. So defendants now can obtain legal advice both at the review date and at the substantive hearing date. And just in passing, I'll make one point here. The reason defendants are given another chance to obtain legal advice is presumably so that settlement can be facilitated. And facilitating settlement is plainly a core part of the overall arrangements. Now, it might be thought that the nature of the remedy sought in possession claims actually militates against the possibility of settlement being achieved at such a late stage in the dispute. And it might be thought that actually the hopes of a higher rate of settlement at the R date are misplaced, but it effectively remains to be seen whether that will be the case. So moving to the substantive hearing, if the case is not settled on the R date or thereafter, and the claimant's papers are in order, then the dispute will be listed for a substantive hearing. So it seems that the substantive hearing will be listed for a minimum of 28 days after the review date. But we note that the overall arrangements state, by contrast, that, quote, the S date should be 28 days after the review date. So it's not clear whether the substantive review date will be a minimum of 28 days after the R date or exactly 28 days after the R date. And there's conflicting guidance on that point, which is extremely unfortunate. So another important point to note in respect of the substantive hearing is that the question of adjournment will be considered without the need for an application in any case where there is no sign that advice has yet been made available to the defendant, and B, the consequences of the order may be serious in the context of the pandemic. That's an extremely vague provision, may be serious. It seems to be quite permitting. But again, it remains to be seen how this is going to be applied by the courts, and we expect that actually the judges have been afforded quite a good deal of discretion. So in terms of accelerated possession claims, notably the above, or what I've just discussed, won't actually apply for the most part to accelerated possession claims. And an order for possession may still be made in such cases without a hearing by a judge. So there are some aspects of the overall arrangements that will apply to accelerated possession claims. And the main ones, it seems to me, are as follows. So under Practice Section 55C Para 2.1, these claims will still require a reactivation notice like all other state claims. Perhaps most importantly, accelerated possession claims will also be considered pursuant to the priorities listed above. And finally, where the parties agree or there is no objection, the judge to whom an APC has been referred for consideration may direct that a review date be listed to enable the defendant to receive duty scheme advice and assistance. And so again, the importance of the defendant receiving that advice is again paramount within this, within the general scheme. So moving now on to the COVID-19 case marking and enhanced information provisions. So these are another core aspect of the overall arrangements, and it seems that these policies have been implemented to ensure that there's acknowledgement that COVID-19 has created unique difficulties for the most vulnerable in society. And this is what those policies, I suppose, are trying to reflect. So in terms of the enhanced information provision, landlords are now required to set out what knowledge they have as to the effects of the pandemic on the defendant and dependents. So this applies to all existing cases where a reactivation notice is served and all new claims, including all accelerated possession claims. So you'll see in the Q&A, Lawrence has asked a question about this. It seems clear on our interpretation of the overall arrangements that the landlord is under no obligation to make inquiries into the effect of the pandemic on their tenant. And in fact, it seems that there may be an inherent risk in reaching out to the tenant and asking about the effects COVID-19 has had on their income or their health or any other relevant matter. And the reason being because if the tenant says, well, actually, COVID-19 has had a substantial impact on me, it's likely that the judge will push that case right back in the queue. And obviously that's not what you want if you're a landlord. So COVID-19 case marking. The basic mechanics of this scheme are that where applicable, the court file will be marked to highlight any case that is or is claimed to be a direct consequence of COVID-19. Now, this is obviously a very important feature of the new arrangement, and it's intended to assist the court with listing, case management, and exercising any discretion available in decision making. And this is set out at paragraph 29 of the overall arrangement document. So, even more importantly, it's open to any party at any stage to request that the case is COVID-19 case marked. The party making that request will be required to provide specified information and must inform all other parties of the request. So if the other party objects to the case being COVID-19 case marked, the court will decide whether the case should be so marked when the file is next before a judge. So in terms of the specified information, I've set this out in the Q&A, and it probably doesn't make sense for me to go through it all again, but if you want to see that, that's set out in the question and answer section. The important thing to note here is that the list of specified information for defendants is much larger than the list of specified information for claimants. And I think that really expresses the fact that the COVID-19 case marking scheme was really designed to allow tenants breathing room where they've been affected, negatively affected by COVID, whether that be in terms of their finances or their health. So another key interaction within this scheme is how COVID-19 case marking will interact with the question of priority. And unfortunately, no guidance has been given as to how this interaction will play out. So, for example, if there's a case in which there's an allegation of fraud, and thus the case falls within one of the categories of priority, what if the defendant in that case has been substantially impacted by COVID-19? How will those two competing factors weigh up in the judge's mind? Well, it seems to us that the answer is that this is ultimately a question for the judge, and it's largely a discretionary matter. And the fact there's no guidance on this really supports that interpretation. So finally, eviction where an order for possession is made, notice of eviction of at least 14 days is now required both in the County Court and in the High Court. So previously, claimants often applied to transfer enforcement from the County Court to the High Court in order to benefit from quicker and more effective enforcement options. But a word of warning here, because the overall arrangements stress that such applications, quote, may not be able to be treated as of high priority. And this is certainly something that should be factored in when considering possible enforcement routes. In passing, it's probably important to note the letter I'm sure you all will have seen that was sent by the Lord Chancellor to the High Court Enforcement Officers Association. And effectively, the Lord Chancellor requested that no evictions are carried out where Tier 2 or Tier 3 restrictions are in place and during the 11th December 2020 to 11th January 2021 period. From what I have read, it seems that the HCEOA members have agreed to this, and it appears that the County Court bailiffs have also agreed to this. So in practice, it seems that what this means is that no evictions are going to be carried out in large parts of England for the foreseeable future, because it's difficult to envisage Tier 2 or Tier 3 restrictions being lifted anytime soon. So that's definitely a concern for landlords. Again, in passing, I note that it's not entirely clear to me on what the legal basis was for this letter, and I'm sure it will be challenged at some stage. So I think it's a case of watch this space. So finally, a few practical points. I'm going to skirt over the first and the third. In terms of the venue for the hearing, parties will always be offered a physical hearing for the substantive hearing, save where A, contingency measures are needed, i.e. due to a more stringent lockdown, contingency measures needed to be introduced, B, the existing provisions for accelerated possession claims apply, or C, where the parties agree that a hearing should be by telephone or video. And if parties want a hearing to be heard by telephone or video, they'll need to make a request in writing. That concludes my bit on the overall arrangements. I'm not sure if there have been any more questions.
We have had a couple. I've just sort of elaborated on your answer to a question about the claim that the court said you haven't made any inquiries as to the impact of COVID on your tenant. Yeah. And with great respect, the court was wrong to try and impose that. There is no obligation, but of course and the practical question was asked: how do we fight it, or is it easier just to go along? I think it's much easier to go along. It's cheaper for your client and quicker. I don't think it's correct, but the court do lots of things that we don't think are necessarily on target. And sometimes you need to appeal them. Sometimes, as I say, it's more efficient just to go with it. Yeah. In that case, it is just okay to go with it. We have a question which I was typing an answer to, but I might as well just answer orally now. Are there any comments as to how the new arrangements will affect mortgage possession claims? In exactly the same way, and the only reference to mortgage claims in the new practice direction is in the existing requirement to bring the form which evidences compliance with that pre-action protocol. So there are no specific changes in mortgage possession claims. I mean, my experience is that the courts always go the extra mile to avoid making possession orders in those claims. And people can, to a degree, can play that, unfortunately. So there won't be much change to the mortgage claims, except insofar as they'll be subject to all the same rules as these other claims. Any impact on IPOs? Well, an IPO is obviously by definition against a trespasser. So that's very good. Stephen Johnson has asked. I don't know. I hadn't thought about this. I've actually got an IPO going on at the moment.
I will note that IPOs aren't discussed in terms at all in the overall arrangements.
No.
I'm not sure that necessarily means that it won't apply to interim possession orders, but that's definitely something to note.
They haven't specifically in the practice direction changed that requirement with respect to any of the IPO issues. I suspect they should go on exactly as before. It's interesting, Stephen. As I say, I haven't had one of those claims. Were they stayed? Does Stephen know whether they were stayed? If you can pop it in the chat, that would be very helpful. I'll come back to that because I haven't got a lot of help for people on that. In terms of stat demands, no, Chris Bowler, nothing is stopping anybody putting stat demands on. It is simply the case of obtaining possession that is being avoided. And in a sense, stat demand is a purely financial remedy. Possession is a physical remedy, and that's what courts are more concerned with. Joanne has asked what a lot of people have asked. Now, I've answered a couple of people. Will slides be made available after this session? Yes, that's what comes around with. I'm pretty sure. Henk, help me here. I think.
Yeah, that's what happens. We've also got 2 articles on this, which kind of may provide a bit more further discussion of these arrangements. If you wanted to look there, I'll send a link on the Zoom chat.
That's very helpful. Yeah, obviously both of our words this morning have been based on those 2 articles. The slides themselves may filter out some of the stuff that may be more useful. So if it's not always the way, I'll make sure that Emma does send them around, but I think it is almost invariably the case. So thank you for that, Joanne. Have I missed anybody yet?
Just showing the link to the
Gloss chat. So look. So Chris, I think, has helped us out saying details of the legal actions. There's no win, no fee JR against bailiff's refusal. That's brave personal, very committed firm doing a JR against the bailiff's refusal. Facebook post of Possession Friend. I presume Possession Friend is the organisation. I haven't come across them. There are many such organisations that are run alongside the more established firms and council getting possession for landlords. IPO, what Stephen's question was based on, he says, I have a client that issued an IPO claim about a month ago, and we've received nothing from the court. So I wondered whether the reactivation notices would apply to this as well. So that if it was against named persons, then it would have been subject to the stay. When you say about a month ago, if it was issued before the stay was lifted, I would think a reactivation notice would apply. If it was against persons unknown, that was not subject to the stay. But the court may have got it wrong. So give them a poke. And as I've said, Stephen, it's easier to issue a reactivation notice and just spend that little bit more time and money for your client and be safe and save them. It's a sort of minor insurance policy. Sarah, who knows everything. Thank you, Sarah Prager, of our chambers. Slides and recording are always sent, and we will make sure that Emma and Henk has also posted the link to the articles, but we will make sure that Emma also sends the articles to everybody who attended, whether you want them or not. think those are all dealt with. That's Henk's links he's posted. That's fabulous. Are there any? Oh, can we still apply for evictions in tiers 2 and 3, and will bailiffs set the dates as and when they can? Yes, there's nothing that says you can't apply for an eviction date. I suspect what you might get back is a letter, or is A, nothing, or B, a letter from the county court bailiffs going, oh, well, it's tier 2 and 3, we can't do it, and we'll let you know. But, for the expense that you're causing your client, it may be worth it to just bang off a quick letter. It really is a whole new world for everybody. What I wanted to think about was the R hearing, the review hearing, which isn't going to give the parties a chance to be in front of a judge at all. I don't know who has to be available when, because it seems like this landlord's representative who has authority to negotiate has to be available potentially all day. And you're not, much as we would love it, you're not going to instruct counsel for that, for a whole day of negotiations that may be, will you leave? No, I won't. I think it's interesting that the group that was working on the overall arrangements was led by, I think he is still Mr. Justice Robin Knowles, who is a very, very experienced QC, but not someone who is a specialist in landlord and tenant and housing. Now, they may well have had lots of specialist people on that group, and I don't know who was on it, but it's interesting because I think the idea of settlement of a possession claim is of limited use, because the very nature of a possession claim is that the landlord wants a remedy, which is possession, and you can't have half possession. You can't say, okay, well, your claim is for 10 grand, we'll give you 5, fine. So your settlement options are, and experienced landlord representatives will, will be saying these in their sleep. If there are arrears, wipe the arrears because you're never going to get it. It's fairy gold. Your client will not get that money. And then your option is to weigh up, well, am I still getting my rent? If not, is it cheaper for me to pay them to get them to go away? Because the likelihood is that if you're starting a claim now, I can't see anybody, unless it's one of the priority cases and very straightforward and effectively undefended, I can't see possession within the next, am I mad, 12 months? It really isn't going to be quick.
Yeah.
And that is going to mean, the commercial reality is that it's going to mean there will be far more pressure on landlords to make some kind of financial offer to go, and far more incentive for tenants to dig their heels in and to hold out for what they think is a good offer, and a landlord may think is an outrageous offer. So it's going to be very difficult. The very fact of the slowdown of cases will, in a sense, work against settlement, because the tenants will, and well-advised tenants will know they're in a stronger position. It's our responsibility to fight for everything we properly can for our clients. So, we'll do it. Like most counsel, I do both sides. The bulk of my work is in tenant side, but I do plenty of landlord work. And I'm always realistic with landlords. I think if you can make them an offer, even before the new world, where things didn't take as long as they're about to take, they're still taking far too long. You know that. How much is possession worth to you? Your asset is your property and your ability to get rent back from it. Make a commercial decision. What's it worth? First of all, see if you can just get rid of them for wiping out the arrears, because there's a saying you'll never get them. But then, how much money are you prepared to pay them? And landlords will face that, and landlord representatives will need to help them think commercially about that. Some will dig their heels in and go, no, I'm the point of principle. Well, points of principle are fine, but they're often expensive. But that's the client's privilege to make their decision based on the best advice they can get, and that's from us. We've got a couple more bits in the chat that I haven't seen. Yes, just make it Robin Knowles, Mr. Justice Knowles, is of course a judge of the High Court and has also extremely important extra extra jurisdictional work in dealing with, I think, clamping down on fraud. So yes, Mr. I think I credited him properly as Mr. Justice Knowles. I hope I did. My apologies to him and to everyone if I didn't. Right. Is there anything more substantive, or do people think I'm now sick to death of this and I just want if there is nothing, I'm seeing nothing open. Are you seeing anything open, Henk? If anybody does have anything they haven't had answered, shout now. If not, our email addresses are there. Oh, somebody has shouted. There are our email addresses in the chat. No, that's just a thank you. That's very kind. Thank you. Thank you for thanking us. Anybody who does want to keep going on anything that we had raised that we weren't clear about, or that anything they want to be reminded of, there are our email addresses. We would be very happy to try and help. Just as this is, I think, the last of our series of webinars for now, thank you to everybody who's attended today. Thank you to everybody who's given them. I've enjoyed doing them. I know other people in Chambers have enjoyed doing them. It's been lovely to actually have some semi-human virtual contact with our solicitors, other people, people who aren't our solicitors, everybody who's attended. So thank you for making the time. We know everybody's got millions of Zoom calls these days and we're all sick of it. Chambers webinars are going to have a short break. I suspect they will be back. I find these have been useful and make some use in the future. Thank you all. And Henk, have you got anything?
Yeah, thanks everyone. I second Richard's sentiments. Thanks everyone for coming today.
Great. Thank you. Now I will sign off and hopefully manage to end the session. Maybe I won't. Yeah, it certainly is a minefield, Henk, but if we can help negotiate through it, all the better. Cheers, everybody. Thank you so much.